have Thanet Lodge's garages. That's being introduced by Curtis, who's been very patiently waiting for us this evening. Thank you. If you can make introductions, please. Thank you.
Thank you, Councillor. The site relates to a garage plot which sits on the eastern side of Thanet Lodge, which is located on the corner plot fronting both Mowbray Road to its south and Maplesea Road to its west. Site's within Bronsby Conservation Area, but does not contain a listed building and is not located in close proximity to a listed building. The proposal involves demolition of the existing garage block, removal of a shipping container, erection of a new 3-bedroom dwelling house with associated amenity space, pedestrian access, cycle and refuse storage, creation of additional hard standing, and to allow the reconfiguration of the parking layout. There was no supplementary report to this scheme. The recommendation is to grant planning permission subject to conditions as set out in the committee report.
Thank you very much. Just want to confirm if we have any questions for clarification from the officer. I don't see any hands. Thank you for that, Curtis. We'll now move on to the public speakers. We have Satbir Singh, who's registered to speak. Thank you, Satbir. I'm sure you're familiar with this evening's proceedings. So, yeah, press the red button when you're ready to proceed, and you'll have 3 minutes. Thank you.
Good evening, Chair. Thank you. My name's Satbir. Brent has been my home since 1987. In 2020, my wife and I bought our first home, which was in Thanet Lodge, a top floor flat. We'd saved for 10 years to buy it. About a year later, we had our first child, and a few months after that, we discovered that the flat itself and all of the top 4 flats, which had been built by the developer here, had significant deficiencies from fire safety to unsafe cladding to a lack of fire compartmentation. Last year, 2025, my mother, who worked for Brent for a long time, had a stroke, and we had to move out of our flat very suddenly to care for her because Brent Social Care was overstretched. We tried to find a buyer, and eventually we did. A few days after my mum died, I discovered that the freeholder and the developer was not going to approve the sale of our flat, nor was he going to confirm that I had paid my ground rent, which I always do. And when I spoke to him, he said he wanted £15,000 from me as compensation for having previously objected to his planning applications to this committee. When I met him a few weeks later, he said he was going to go one by one through everyone in the building who had ever objected to his applications and make them suffer. I recorded both of those conversations and passed them to the Metropolitan Police, who said that they found that incredibly concerning, but that there is too much crime and they have too few resources to investigate. Since then, as he prepared for this meeting and for his application to be considered, the developer has gone through a number of leaseholders in the building and informed our mortgage lenders that we are at risk of forfeiture and that we are in breach of our leases. All of our mortgage lenders and our lawyers have confirmed that there are no breaches, that the intimidation is the entire point. Other leaseholders are now so frightened that they object anonymously or they don't object at all. It is no accident that I am the only one of my fellow leaseholders who are all with me on WhatsApp and Signal here tonight in person. I can't sell my flat, but that's a small fry compared to the bigger picture here. I work every day with campaigners and MPs and ministers and journalists on all sorts of issues, including housing. I don't need to be told that we don't have enough housing, but this is a 3-bedroom house in a fancy area of London that's going to sell for £1 million. Nobody is desperately waiting for that house to be built behind our dustbins. You as a council have to weigh a developer's record and the credibility of their promises. As the paperwork lays out, those promises have been broken many times. To grant permission risks the reputation of this committee, of the council, which has duties under the Local Government Act, the Representation of the People Act, and the right of all of us to participate equally without any intimidation. And so I strongly urge you to reject this proposal.
Thank you very much, Satbir. I appreciate keeping to the time. Just want to see if any of the committee members have any further questions that they want to pose to Satbir. Sorry, 1 second.
Yeah, I'm really sorry to hear about your experience here. In terms of what the what the planning committee are able to consider tonight and what we are able to consider as a local planning authority. We can't consider what is said about the behaviour of an applicant or their past record on fire safety or anything like that. We have to consider that the proposal that's in front of us tonight. So, I'm really sorry to hear about the things that you've experienced here, but we're not legally allowed to take those into account when considered as planning application. I'll ask if Paul Weeks our lawyer can come in just to confirm that what I'm saying is correct.
Yes, that's correct, David. The application needs to be considered solely on its own merits, looking at the material considerations, relevant planning policies. Those matters that have just been raised are not things which go to the acceptability of the proposal in planning terms, as serious as they may sound. We need to limit the consideration to the merits of the planning application and balance that against the relevant policies.
Can I pose can I ask you a question then? Just about your responsibilities under the Local Government Act, under the Constitution of Brent Council. So if the,
So
if
what,
the process
as
of
per
this
my
council is
introductory
perfected or
statement,
perverted-
we're a quasi-judicial, so
Yeah.
we're not bound by any sort of party politics, or we just decide on the planning
familiar with
guidance.
that
Completely.
completely. But my question is, because you're obviously talking to me about the process that this council follows, and you rightly have it written down, codified, by the letter of the law process. But what I'm putting to this council, to this committee, and which I've put in writing and others have put anonymously, is that the very process of this committee, part of which is to encourage and permit fair and full participation in consultation. If that has not taken place, to whom do I go with that? You have asked other applicants in this meeting. I've sat patiently for 3.5 hours. Did you have a fair consultation on this? Did you have a fair consultation on this? So it comes to mind that that somehow matters to you, right? That is material to your considerations, whether or not there has been a fair and full consultation on an application. And all I am bringing to your attention is that there has not been, because, as I have laid out, members of my leasehold community have been intimidated out of participation quite explicitly. And I'm asking you if that is not a matter for this committee to consider. To whom should I go?
Yeah, so this is not
Do I
something that
require
we
plenary
can advise you
legislation?
on at this moment in time. We are here to consider this planning application. If you do, I would suggest that you take up alternative legal advice in that respect. But it's not something that we would be able to advise here and now this evening. Maybe later on, if you want to reach out to one of the officers or one of our planning lawyers here tonight.
We've spoken to.
It's but yeah, it's not something that we can take into consideration or discuss any further in regards the actions of the developer. It's only what's material planning considerations. David.
Yeah, and this isn't a Brent rule. This is about what we are legally able to consider and what we're not legally able to consider when we're looking at a planning application. So, and we can't work outside of our legal
Of course,
authority.
I
So,
don't expect you to, but I'm just asking, when a question was asked of an earlier applicant, whether or not they had had a proper consultation, and it was asked of Kingsbury High School how wide their consultation was. My reading of that is that, in your opinion and in the opinion of your code of conduct and your code of practice, that is a material consideration for the committee.
Yep, and the applicant will be coming and speaking to us
Wonderful.
very soon. So I'm sure the committee will pose those questions. Councillor Georgiou, please proceed.
Just a suggestion, Chair, and please, if I'm out of turn, please do say, but given that the resident is the only resident here, would it be at all possible to allow him, if he's willing and able to speak directly to the issues in relation to this application, so that we can hear from a resident about why there are concerns about this particular application, so that we can ask some questions as well?
Councillor Ryan Hack, who's aware of them as well, but I'm happy to speak to those issues as
I
well.
mean, would it be possible to allow him some additional time to just speak to the specific concerns that residents have with the application? Because right now we can't.
You're welcome to ask a question which would prompt the answer.
Sure. What are the specific concerns that you have with this application?
Firstly, this I think we believe is an example of overdevelopment. This is a block of more than 40 apartments, which has constrained land around the rear and the side. That land has already been parceled off as part of the developer's construction of his own home. The proposed building, this house, is essentially going to be built behind the dustbin area where 40 plus apartments throw their rubbish and do their recycling. The area that allows you to drive into or enter the rear of the building is about 2 to 3 meters wide. You'll have the exact figures on the drawings that you've got. And what the development essentially does is it replaces the garages which sit there on the side of that entryway with an entire home, which will sit adjacent to the building or will face the building directly. We note from the drawings that, and the amended drawings, that considerations have been made about light and the 45-degree angle and all the rest of it. But what we're talking about here is constructing an entire house where there is currently a garage behind the dustbins of a large condominium block, which will open directly onto the driveway of the building. As part of the proposal that sits with you now, there are also questions about whether it keeps in with the character of the neighborhood as a conservation area. There are also questions about the requirement for this development for them to remove trees from the garden. The garden provides amenity for the 40 plus apartments in the building, many of whom, including myself until recently, had kids. And the parking spaces which sit behind the building, parking's been very popular with you all tonight. But the parking spaces which sit behind the building, there are about 5 or 6. 4 of them are actually part of the leasehold of the apartments. One of them is mine. Those are being removed or moved as part of this development. And so there is a direct conflict there between property rights, between a proposed development and actually moving the property on leasehold of somebody else, rendering some of those parking spaces unusable and impeding into the garden. But as I said, the first point is really that this is just a really clear case of overdevelopment. London needs houses. We all need houses. I don't think we solve the housing crisis with like a really expensive house that's built behind some dustbins in NW2.
Thank you very much. Do we have any other questions from the committee to? No? Okay. Thank you very much, Satbir. I appreciate your time this evening, and apologies once again for the delay.
Oh, it's all right. I learned so much, guys.
Thank you.
I'm going to read about turf when I get home.
Now, our next speaker is the ward councillor, Councillor Ryan Hack. Please take a seat. You know how the system goes. 5 minutes when you're ready.
Thank you, Chair, members of the committee. I want to speak today and urge you to object to this application. This is not a modest redevelopment. It is a clear overdevelopment of a constrained backland site that will cause significant harm to neighbouring residents, the surrounding environment and the character of the Brondesbury Conservation Area. The proposal replaces an open landscaped area with an intrusive residential development that's entirely out of keeping with its setting. The spacious rear gardens are an important characteristic of the Brondesbury Park Conservation Area. And this scheme would erode that character, contrary to the Brent Local Plan Policy BHC1 and the London Plan Policy D3. Residents of Thanet Lodge have also experienced material loss of residential amenity if this is approved. The proposal replaces a low-level, unobtrusive structure with a much larger and more dominant building. It will result in increased overlooking, loss of privacy, reduced daylight, and a greater sense of enclosure. This scheme also removes valuable garden spaces I've highlighted and vegetation. There are equally serious concerns, as my predecessor spoke about, the leaseholder rights. Existing garages will be removing, parking spaces that are part of a legal framework of 900 years. Many residents wished to attend tonight, but felt that they were unable to because of the intimidation of the freeholder as well. That leads me on to another important point. These applications should not be viewed in isolation. There is a concerning history of planning and building compliance relating to the wider site. In around 2019, as you spoke, the freeholder decided to erect a neighbouring amenity, and following construction, residents reported subsidence and cracking within Thanet Lodge. Furthermore, concerns have been raised that elements of the approved planning permission have not been implemented, including the omission of the approved green roof, failure to carry out the approved landscaping, extension beyond the approved garden boundary, and the erection of structures within communal gardens without planning permission. How on earth can this committee have any faith in the freeholder to carry out any of the obligations or conditions if this is approved? These matters are relevant because they raise legitimate questions about confidence and compliance with planning conditions attached to any future permission. As the local ward councillor, I'm deeply concerned by what appears to be a repeated pattern of non-compliance and disregard for both planning requirements and the interests of residents. Members are therefore asked not simply to approve another dwelling, but to permit further development on a constrained site with a conservation area, despite significant impacts on a residential amenity, loss of green space, biodiversity, parking arrangements, drainage, and the historic character of the area. For all of those reasons, I respectfully urge the committee to refuse this application.
Thank you very much, Councillor Hack. I do appreciate you sticking to time. Before we do move on to questions from the committee, I'm going to need another show of hands, please. We've reached 9:45 just nearly, so just for a quick extension. Thank you very much. Councillor Gallagher, I saw your hand up for a question, so please proceed.
Thank you very much, Councillor Hack. What you've said is deeply concerning. You and the other resident, bullying, intimidation, aggressive behaviour. Are you aware of any codes of conduct or, sort of standards that are expected of applicants in the planning committee process at Brent Council? Because I would have thought that there was one to avoid this type of conduct.
What I will say is these concerns have been relayed to the council, to the Metropolitan Police as well. As I mentioned at the beginning of my remarks, there's over 20 people who wanted to be here tonight. Not just leaseholders, but there were tenants who wanted to come here to speak about the various issues that are going on at Thanet Lodge. It's quite shocking. When you look at the development that already took place that was adjacent to this building, subsidence that was caused. I have concerns about drainage and material issues that would be a direct result of what this development would cause, and also about the policies that it would contradict, about the affordability, about if this was to be built. Would this be just a direct streamline to a freeholder, to someone who is going to continue this sort of behaviour that not just treats Brent Council in contempt, but local residents as well? Freeholders have a responsibility to treat people with respect, to follow frameworks that are clearly laid out in national legislation as well. And I would expect that to be considered tonight as well.
Is that okay? Yeah, Councillor Georgiou, please.
Thanks, Ryan. So as the local councillor, you're well aware of the area where Thanet Lodge is. Could you just explain to the committee the characteristics of the area? I know that it's within the Bronsbury Park Conservation Area, and your resident talked about the fact that this would amount to overdevelopment. Just explain why that would be and just the general characteristics of the overall area.
Yes, so the Bronsbury Park Conservation Area was largely created in the late 1800s. It was largely townhouses that were highly erected. It was to preserve not just grand buildings, but the real characteristic of a conservation area. As I mentioned before, it's also about the land, the green space as well. And I believe we've seen, evidence, as I mentioned, that this application shouldn't be treated in isolation, about conditions that haven't actually enhanced the conservation area as well. I do not believe that this development would add any enhancement to the conservation area that was largely created in the late 1800s.
Can you just further expand on the overdevelopment point? So in terms of the size, the scale, what's around it? We didn't do a site visit, so I don't really know what I'm.
So the application, again, as I've mentioned before, would take away, parking spaces. It would take away green spaces. You mentioned about a site visit. I do not understand why one wasn't arranged by the planning committee. Could you please inform me why that didn't take place?
So we had one arranged site visit with officers. All other applications, committee members were advised to visit by themselves and make themselves familiar with the sites. And that's pretty much the same. We only tend to visit the large schemes where a greater understanding is required for the site context, but the recommendation and the expectation is for members to make their own visits in their own time who are on the committee.
And when the site visit had taken place, did you take any review about the development that was previously part of the adjacent building? Did you ever review the fact that there were breaches in the planning conditions? Did you not, consult residents about this, take that into consideration?
Just for members' benefit, as I was saying before, we can't take into account when considering this plan application, any matters to do with an applicant for another planning application. We have to consider this application and its merits. That's legally.
But there can
what
be an
we're trying to
overlap.
do.
So not an overlap, but there can be some parallels. So, for example, if a previous, application, and you have to take this in as an individual merit on what this is part. But if a similar application was taken forward, and there would be breaches in planning conditions, there would be subsidence caused, there would be drainage issues, there would be loss of light. Those are material, merits that one could take a consideration of.
They most probably are, but it's not something that we could consider as part of this planning committee. We can only consider the application that's in front of us in regards the planning guidance that applies and the officers have referred to within the reports. Anything outside of that, unfortunately, we really wouldn't be able to consider whether that includes someone's character or their financial dealings or anything like that. So, yeah, in answer to your question, unfortunately not. Councillor Gallagher?
This is probably a point for the legal officer, but where a consultation process is compromised through bullying and intimidation, and we now have two people to speak to that, surely the process in its totality is compromised.
There are statutory requirements that need to be met in terms of the consultation of a planning application. If all of those matters have been met, then, the statutory requirements for every planning application, the consultation processes that need to be done. If those are all met, then legally the correct process has been followed in terms of consultation. In terms of, sorry, can you not hear me still? Yeah. In terms of what's been said, it's not really the role of this committee to make a judgment on those matters. And it's very difficult. I'm not saying one way or the other. We haven't heard from the applicant as to whether or not these whether or not they would accept these things that have been said. I don't think this would be an appropriate forum in which that to be carried out. It's, I won't lie, it's very, very difficult, but we come back to the fact that in terms of the consultation has been done, as far as I'm aware, in terms of site notices, those things, publication, people are given the opportunity to respond. If there is a reason that people have not responded, then that is potentially a serious matter, but it's information that we can't say with certainty.
It's going to pick up.
I think Councillor Hack is pretty certain.
If I just pick up in the consultation. So just to clarify, the initial consultation was in April, where 66 addresses were consulted. So that included all of the properties in Thanet Lodge and those sort of adjoining the site nearby as well. There was 2 rounds of consultation carried out, one in December 2025, and that was in to include the enlargement of the parking area. There was a following subsequent consultation, essentially on the same plans, but to clarify in the description of development, the works to extend the hard standing, because that constitutes development, so it captured everything. Press notices and site notices were also displayed. So the consultation was carried out in accordance with statutory requirements. As we summarised in a committee report, there was a number of objections received, 20 in total, some of which submitted multiple comments. 7 of these were without an address. So we did still consider the objections. I think what's important when you note about when a case like this would only go to planning committees if there's 8 or more objections, that has to be 8 or more objections where an address is specified as a resident in Brent as well, or a business in Brent. So we did receive more than 8 objections with addresses to then enable the case to go to committee. If there was less than 8 objections, so if we had the other way around and there was 20 objections but none had the address, we would still consider them as officers as objections, but the case wouldn't then be presented to committee. But in this case, there was over 8 objections with addresses, so the case was then presented to yourself as a committee.
Thank you very much, Victoria. Councillor Maurice?
Yes, I'm very concerned about this intimidation thing. And I realise what the legal officer is saying.
Sorry,
but-
I just want to, we've still got Councillor Hack sat there. I thought you were going to ask a question to Councillor Hack.
Well,
so if we're finished with questions to Councillor
okay,
Hack,
right,
ask
then
him
I'll
to
bring
take-
it up. I'll bring it up with the
Just in a
officers.
sec, yeah. Let's, Councillor Hack, thank you very much for your time. We'll move on to questions to officers now. Councillor Maurice, you're more than welcome to continue now. Sorry to interrupt you.
That's okay. Would it? I'm looking at this from another point of view. From another point of view, that if there is proof that there has been some sort of intimidation and telling and sort of stopping people from making the right
Councillor Maurice,
sort of decisions, is that not the same as, say, jury nobbling or intimidating a jury in a trial?
I'm afraid that's something that these are all allegations. None of them we have confirmed. We're not judge and jury. But what I will say is we need to move on to the applicant to hear the applicant. So if there's any questions that we think may be, directed at the applicant, that may be the best time to put them through. So next, I'd like to invite Michael Burrows, the applicant, to address the committee, please. Yeah. So before we proceed to hear the applicant's intro, David has a question.
Thank you for joining us tonight. Can I just ask something, a question of clarification, because we've heard tonight that from the speaker that he believes that there are residents who own a lease on parking spaces that are within the application site, within that parking area. Can you please confirm whether or not there are any parties other than the applicant who have a lease of a length of 7 years or greater anywhere within the application site?
I'm not an expert on this. I know anecdotally what the situation is. I understand there are 4 parking spaces on the site and they're let out on an annual tenancy. Is that right? Can I look at the... yes, they're linked to the penthouses. So there are 4 penthouses and 4 parking spaces on the site. They're rented out for periods of less than 7 years, as I understand it. So, so there isn't a notification issue, which is what you're getting at.
Thank you very much. Is that address your point? Yep. Yep. Super. So you'll now have 5 minutes to address the 3 minutes to address the committee. Before I do progress, we need another extension. We're reaching that time, 10 o'clock. Just get a show of hands, please, to move across. Thank you very much. Apologies for the delay, Mr. Burrows. Please have your presentation.
This is a wonderful place to be delayed in, isn't it? So I think the first point is point about intimidation and objections. If you go onto the council's website, there are actually 22 objections listed on the website. So that must be 22 out of something like 60 notifications. That's a pretty good response, I'd say. You can't read all the objections because for some reason they don't appear on the council's website. I think that's a problem because all councils have to be transparent in the way they've made the decisions. And if there are objections that are being considered by the council, but not available to the public, not available to the applicant to look at, that's an issue. And I suspect it's a statutory issue. It's not a big point because the objectors tend to make the same points. The points the objectors make are utterly different to the points that have been made to you this evening. And I've spent the last half an hour trying to puzzle out how you'd actually frame a refusal on the basis of what you've heard. You can't turn a planning application down for reasons to do with, I don't like the character of the applicant. And, you know, these boys are shooting at entirely the wrong target. It's like the football analogy. If you're no good at kicking the ball, you kick the man instead. And they're certainly kicking the man as hard as they could. But that doesn't get you through the World Cup. It gets you sent off. And I can't help feeling those two should be sent off, actually. So, I mean, it's very late. To get to the nub of the point, there are 3 good reasons, it seems to me, why you ought to approve this. The first is, despite not being told this by any of the objectors, there's an outstanding planning consent on the site to redevelop the garages with a single-storey flat-roofed building. So the acceptability of principle of residential redevelopment on this site is well established, and really that's the first good reason. If the application is turned down, all the applicant's going to do is, he's probably going to appeal it if it's turned down, but all he's going to do is build out the flat roof building, which is a less attractive building than the pitched roof building that we're seeking at the moment. It's going to enhance the conservation area because just about all the buildings in this area are pitched roof. There are hardly any flat roof buildings, and in fact, there are no other flat roof buildings other than Thanet Lodge that I can think of. It's been designed to look a bit like a late Victorian
If you could finish up, please, time.
stable or garage. The third good reason is that the case officer, who's a very thorough, very decent case officer, who I've spoken to over a long period of time, is recommending approval. And his long analysis is analysis I'd endorse entirely.
Thank you very much, Mr. Burrows. I do appreciate that. Councillor Gallagher, I can see your hand up, and then followed by Councillor Mahmood.
Outline to me what's going to happen with bin storage, because I am not quite at the bottom of that in respect of where the bins are currently. And also, can you outline to me what is meant by the self-build development? Because I know that you don't have to meet certain targets because of self-build,
Yes.
and what your plans are around self-build. And then also the urban greening factor. You haven't achieved the 0.4 rating that's required. And if you can outline there what's happened in respect of that. Thank you.
Okay. Three questions then. The first is bin stores. The bin stores are in precisely the same position as in the approved scheme. The council approved bin stores in that position, and there's no reason why they shouldn't approve it again. What was the second one?
Self-build. So you don't have to meet certain biodiversity targets because this is described as a self-build, and I want to understand exactly what that means.
Okay. Self-build is a concept that came in first with SIL. If you had if you were a self-builder, that is, you were a man who was going to live, or a woman who was going to live in the dwelling that they'd constructed for 3 years, then you're a self-builder, you're classed as a self-builder, and you don't have to pay SIL, you get a SIL exemption. It's relevant in, well, it will be relevant in this case because there will be a SIL exemption in this case. You don't have to apply for that until you've got a planning consent, though. So that's the thing that's in the future. If you're a self-builder, you're also exempt from BNG, biodiversity net gain. So the requirement to do an ecological report and that kind of thing. I have to say, in this case, you're also exempt from BNG because the site is a small site. So so you don't have to do it on that ground. And I suspect you're also exempt. It would be unreasonable not to be exempt because exactly the same site has got consent for redevelopment. And, you know, if the BNG issue is a serious issue, then they'll just lurch back to the previous consent and design that one. And the third, I can't remember the third one either.
Urban greening factor, you fall short on that, and I think you're not exempt from that.
Urban greening is hard. Well, the policies on urban greening recognise it's hard to do urban greening on small sites, and they suggest that there should be a tolerant approach on that. The urban greening factor that we've calculated is fractionally short of the 0.4 figure that's required. And it does seem to me that the special circumstances of this site mean that's actually a particularly appropriate, a jolly good effort for getting the urban greening up to the right level. This is a site that's essentially a concrete site. It's not going to have any, hasn't got any green on it at the moment. And the site's going to be a good bit greener once this development is completed than it is at the moment.
Lastly, the allegations of bullying and intimidation through the consultation process. What do you have to say to that?
Well, I've heard the theatricals that have gone on. I don't know whether they're true or not. I'm not closely enough involved in the ins and outs of what's going on around here. There's one hard bit of evidence that I've mentioned. The council sent out 60 consultations. They got slightly more than 20 back. And it seems to me there's no evidence. That's a jolly good return, actually. There's no evidence in that people are bullied. Most of the objections that I've read are standard planning objections. Nobody's alleging bullying in the objections. So it does seem to me that you're being bamboozled here. You've got two loud speakers who come forward and made these allegations, and there's really no backup for it.
Thank you very much. I don't see any other hands from the committee, Mr. Burrows. So if you'd like to take your seat back into the public area, you want to, sorry, Councillor Mahmood.
Thank you very much, Chair. Mr. Burrow, I understand, and you've just repeated that there's been a 60+ consultations. There were 20 objections or majority of objections. How many responses in your support of this project?
So I didn't hear those last few words.
I said,
Councillor Mahmood, we can ask that to the officers in regard to the consultation. They might not have all the information, only we will have that.
okay, so I'll leave that to the officers then.
Thank you very much.
But I've got other
Yeah,
questions.
please do.
Yeah,
Please do.
okay, thank you. Through this development, there will be trees lost, some good healthy trees will be lost, as well as green space will be lost to hard standing in the application. Also, I believe that there is an opinion, there is an overdevelopment site, because has there been an application in the past for a smaller property development than the current one?
I mentioned that in my talk. There is an outstanding planning consent for a building that's slightly larger than the garages, a single-story building with a flat roof. That's a planning consent that will run for another year, so it's entirely implementable, and it's there as a fallback that the council must take into account when they determine this application. It's not going to make much difference. You know, you either get an ugly flat roof building or you get a more attractive pitched roof building that's consistent with the character of the conservation area, which is a conservation area of pitched roofs.
But I understand that the actual size of the plot hasn't increased. It's the same as it was then. So don't you consider that this is from 1 bedroom to 3 bedroom, that is an overdevelopment?
No, this is making full use of a developable site, and that's what your policy requires you to do.
Okay, thank you.
Thank you very much. I don't see any other hands. I'm looking again and again just to make sure I don't miss anyone. So thank you very much, Mr. Burrows. If you'd like to take a seat in the gallery, we'll now direct our questions to officers. We still have 7 minutes before we need to raise our hands again. So I'll quickly move on to questions. Does anyone want to kick off to officers? Please fire away, Councillor Gallagher.
Can you outline for me again how one meets the criteria of the self-build development and therefore the biodiversity net gain targets are not achieved, and you know what sort of scrutiny of this development has taken place to ensure that it meets the criteria?
Like, can you just repeat the question? Sorry. Yeah.
Let me come back to it. So
Okay.
self-build.
Yeah.
Okay, does that simply mean that the freeholder is contracting out to a builder to build a house? I mean, what basically, how do you meet the criteria of being a self-build and therefore the biodiversity net gain targets don't, you know, are irrelevant to you? So I'm talking about paragraph 85. The applicant has declared that the proposal will be a self-build development, so will be exempt from meeting the 10% BNG target.
Thank you, Councillor Gallagher. So self-build, that is where self-build and custom build is when a house is built for the purposes of you as the applicant to live in it. So it can be a builder that builds it for you. You don't have to physically build it yourself, but it's for yourself to live in. For it's a 3-year period where you can't then sort of sell it or allow anyone else to live in it. So it comes down to BNG. Self-builds are exempt from BNG. And still, yes. And still, sorry, yes, yeah, as well. There's other criteria where schemes wouldn't be exempt from BNG. One of them is called a de minimis test when less than 25 square meters of habitat is affected. In this case, with the Red Edge site plan that extends into parts of the car parking area and the communal garden, there is a tree in question. Whilst the plan's showing it to be retained, concerns were raised by our tree officer that potentially that tree could be, there's a real risk that tree being damaged during the course of the application because of the difference in the levels with the car park and the garden area. The tree officer in principle was happy to do removal of that tree, subject to suitable replacements. But if you're going back to BNG, a tree is the habitat of a tree. There's quite a detailed metric. It comes from DEFRA, but a tree is about 41 square meters, even a small tree of habitat. So therefore, if that tree is affected, it would then, if it wasn't a self-build, would then trigger the BNG. So what we've done in other schemes is, if for whatever event a scheme is not then self-build, how do we claw, how do we get the self-build back? So what we've done in other schemes, we're proposing to do here, is we would say, we would do it through a legal agreement where we require the applicant to provide the biodiversity base value of the site. And then for whatever event, if, it is not then developed as a self-build, there is a requirement then to provide the BNG through the offsite habitat credits. So it enables us to be able to capture that back. So, we have to assume that it will be a self-build and it does meet that exception. But it's in the event if it wasn't, how could we then enforce against it? And it's through the legal agreement.
Councillor Patel.
Yep. The intended development is within the Brownsbury Conservation Area, which is characterized by Victorian villas. And the intended development is between the pair of Victorian villas. Also, the street is maintained and preserved as such. So could you comment on the design, whether it will be within the keeping of this Victorian villas or something different? Thank you.
Yeah, it does use some materials, particularly such as protecting coping stone, red clay tiles, which are quite sort of commonly used within this area of the conservation area. I would like to also note that the existing garages at the moment are quite unsightly, and they don't really contribute anything to the character and appearance of the conservation area. Creating a dwelling of this type, which is in terms of its scale and materials used, is quite sympathetic. We consider to character and appearance of the conservation will be able to preserve the character and appearance of the conservation area. And obviously we have the public benefit that's provided in terms of the new family-sized dwellings. So we consider that overall the impact on the conservation area particularly is quite sympathetic and it preserves the character.
So we did consult the heritage officer on the proposal, and his view was that, it would preserve the character and appearance. Going back to Curtis's point on the garages, they're sort of more contemporary in their construction and not considered to be any special interest. So there's no objection, they don't contribute to the character and appearance. So there's no objection to their loss. During the course of the application, there was some amendments that the heritage officer wanted, and to do with the fenestration and the materials of it to make sure that it was sort of, more in keeping. Their matters were provided, and the heritage officer was happy from a heritage perspective.
Thank you. Before I move on to Councillor Georgiou, I just need another show of hands, please. Yeah, extension. Thank you very much. Councillor Georgiou, floor's yours.
So I don't mean to labour the point, but we did have a considerable amount of time at the start of the meeting with several of the speakers making some allegations. Could officers confirm whether the council were made aware of these issues that we've heard about today?
Yes, there was matters raised, and as we set out in the committee report, the matters was the behaviour of the applicant wouldn't be material planning considerations, and that is set out in the committee report.
Sorry, can I ask to speak?
I'm afraid not. You should be sat in the public gallery outside over there. Unfortunately, you can't. As I mentioned at the start of the committee meeting, only listed speakers, and that opportunity has now gone. It's the debate between the committee members and the officers at present. So unfortunately, no, you can't.
Okay,
Thank you. Sorry, where were we? Councillor Mahmood?
Yeah, thank you, Chair. Earlier on, I asked a question from the applicant, and I was told that I should address it to the committee, the officers. Out of the consultation process, how many supportive responses for the applicant were received?
We didn't receive any in support.
None,
No.
zero.
Zero.
How many objections were there?
Well, we have 20 objections as listed in the committee report.
How many actual responses were they received? 20 altogether?
Yeah, yeah.
And they were all against the application.
Yes, yeah.
Okay. And secondly, I would like to know, there will be a loss of green space due to the hard standing area. We aspire actually normally to actually have more green spaces rather than losing green spaces. Why is that acceptable?
I'm just going to pick up on your, just with the consultation, obviously Curtis to clarify the number of objections. Obviously, we do consider all comments that are considered in with a planning application, and they do form part of the consideration of an application. And obviously we consider ones that raise material planning considerations. But an application has to be assessed in line with planning policy set out in a development plan. That is what we are sort of legally required to do so by law. If an application has a huge number of objections, that doesn't mean if it's acceptable in terms of considering it against the policies in the development plan, it wouldn't be a grounds for us to refuse an application on. Likewise, if we had, hundreds of letters of support to an application, if it was contrary to the development plan and there was, harm identified, we wouldn't support an application if you were going the other way as well. So it has to be based on planning policies.
Okay, but I asked about the green space loss. Why is that acceptable?
There will be, as a result of the extension to the car park, a minor sort of infringement into the communal amenity space. That's about 1%. The overall site, obviously, the site where the garages are, that will be enhanced with new landscaping to the front and rear. That loss has been weighed against the provisions of a new dwelling house or a family-sized home.
Okay, and last thing about the overdevelopment of the property. It's been extended from 1 bedroom to 3 bedroom now, and it is going to be a house. You've got all these flats next to it, and don't you think it would be out of standing with the local conservation area?
So there was a 2-bedroom house approved in 2024. This is now a 3-bedroom house. It complies with space standards in the London plan, and it also has its own private garden exceeding 50 square meters. So in terms of overdevelopment, it fully complies with relevant standards, space standards. Yeah.
Yeah.
Yep.
We've also carefully considered the impact on neighbouring amenity. So it's looked at the impact of residents on Thanet Lodge, Mowbray Road as well. We recognise that it will be taller than the garage site and there will be a degree of harm to that. And that has been discussed within the committee report. But that has been weighed against the benefits of the provision of the home.
Okay, so we were told there's one dead tree there, which is going to be obviously removed. How many trees other than that are going to be lost?
Only one tree. We were saying that the likelihood is it's going to be severely damaged, which means it will have to be removed. But we are securing through condition of a placement of 2 trees to compensate for the loss of that tree. The other trees will all be retained.
Okay, thank you.
Thank you very much. We have Councillor Georgiou and then Councillor Gallagher.
I'd like to refer back to the question David asked at the start of the meeting, when the applicant was speaking in relation to the car parking situation and the potential for there to be a conflict over the loss of car parking space for existing residents. And that was alluded to in the residents' statement as well. Where would that leave us if we were to proceed in this instance, if we allow the development to go ahead and for that conflict to exist going forwards? Where does that leave us?
Can you clarify what you mean by conflict? Do you mean the loss of the parking spaces?
Yeah, so there will be a conflict between the people who will be losing their parking provision and the fact that this development would be there to replace it.
Did you? Yeah, do you want to jump?
Sorry, we've been researching a different matter in the interim while you've been asking the questions, and this is around ownership and whether or not there are any legal interests in ownership interests within the application site for a period of more than 7 years. Yeah, 7 years or more, sorry. Why this matters is within a planning application is a legal requirement to complete the right ownership certificate. You don't have to demonstrate you're the owner at that point in time. You declare whether you're the owner, whether you're not the owner, and you know the other owners, or whether you're the owner and you don't know the other owners. And there's another category if you don't know their addresses and so forth. But yeah, so it's a legal requirement to complete the correct ownership certificates. What led us to wonder about this is the speaker had referred to leaseholds within the application site. So that is why I asked at the start of the agent if he was aware of any, which he wasn't aware of any. We, in the interim, we've been looking, gaining access to the land registry system, and that has placed some doubt in terms of the ownership certificates that have been completed. Certificate A has been completed, which is a declaration that the owner of the property owns all of the land within the application site. Given that this doubt exists, as there are leases which refer to other names, I now recommend that this application is deferred to a later planning committee for us to evaluate whether or not the correct ownership certificates have been completed. The reason I'm asking for a deferral for this is because, in my mind, having a look at the evidence that we've been able to find tonight on land registry, it doesn't appear to be the case, but we would need to confirm this formally.
Councillor Gallagher.
Officer Glover, I have something else for you to add to your to-do list, because I've been looking up the legislation in respect of self-builds, and the definition is for individuals or associations of individuals. They qualify for self-builds. My understanding is that the freeholder in this instance is Java Properties International Limited, based on Finchley Road, and so query whether or not a company can apply to be a self-build for the purposes of the legislation. I'm not sure of the answer to that, but it clearly says individuals or associations under the relevant legislation. Thank you.
Super. So
Then was
vote on a deferral. So after considering what Dave Glover, Head of Planning, has just said, I have to move to a vote for deferral. So all those minded to defer this application, please raise your hand. Thank you very much. That accepted?
Yes.
Yep. So that actually brings the business for tonight to a conclusion. The next planning committee is the 5th of August. Thank you everyone for your patience and perseverance with everyone tonight. Thank you very much. Have a good evening.